Good afternoon, everybody. I am JD Hoovener, host of the Bold Inventor Show, and that is what this is. I'm a patent attorney, and I own Bold Patents law firm you see behind me. We help inventors and entrepreneurs move forward with their inventions, trademarks, and innovations, help them protect that with patents, trademarks, and trade secret protection. Got my co-host here with me, as always, Matt Kulseth. Good afternoon.
Howdy, howdy, howdy.
Howdy, howdy. Man, all right. Well, we're doing Movember. We talked about this yesterday on our Bold Lawyer Show, but today we're continuing that in this month. A little tip of the hat to Men's Health and the awareness there on Movember. I was blown away. I did a Google search. Started with a couple guys, like in 1997, and now it's like
a couple mustache enthusiasts.
Yeah, and now it's like worldwide, 700,000 members. So go check it out. If you're a guy out there listening, live or after the fact, go get checked out, get your health taken care of, get your screenings, and
doctors are friends.
Doctors are friends. Yeah. I got to break the stigma. It's not cool to be sick.
It is not. No. I'm a volunteer firefighter, and I see a lot of sick men. An unhealthy lifestyle. So. Yeah. Get checked out because it's important, because you don't want to be an 80-year-old man who can't walk.
Yeah, dude. Getting old ain't for sissies. Or you used to say it. Say your one-liner.
Oh, getting old's for the birds.
Getting old's for the birds. Any out there?
My grandma used to say that.
I love it.
She was from Minnesota here, but yeah. I don't know what it means.
That's all right. If anybody out there, if anybody has any ideas of what that means, I'd love to hear from you. Hello out there to our live listeners and watchers. We want you guys to participate, please. We'll take any questions you've got, on subject or not. Bring it on. We want to have you ask away. We're not going to be able to give legal advice to you specifically. We're not your attorneys, but we'll happily do our best to give it a good swing and answer the process question, things related to intellectual property, patents, trademarks, you name it. So, and if it's your first time watching us, give us a like if you like what we're doing here. We're attorneys here. Letting down our guard, kind of just sharing in a live fashion. Give us a like and subscribe to our YouTube channel too while you're at it. So let's do this. This is part 2. I did last week solo, but we're continuing this month down this journey of looking at a company called Beard Face. Beard Face. I did a Shark Tank critique last week. I don't know if you saw it, but it was pretty quick too. But it's kind of a Christmas theme pitch where you put on basically a hat, like a Christmas style, warm beanie style hat, but it's got this strap that goes underneath, and it's got a costume, right? You basically get a beard, like Santa beard.
You get a beard, you get the chops, you get whatever.
Yeah, exactly. I'll see if I can pull it up here. They're still selling. They were looking for investment. They didn't get any takers. Is it Beard? Not Beard Face, Beard Head? Beard Head. Maybe that Beard Head. That's what it is. Beard Head. Okay. Let's take a look. I'll show you what we're looking at. Sorry, podcast listeners, you can't quite check it out, but you can go to beardhat.com. And it basically is on the front of our podcast as well. So they've got different styles here. They've got a sale going on. This is their collection. You got the Barbarians collection. I mean, they're selling 7 figures worth of this stuff. Novelty items for sure.
Yeah, this was the hot ticket, 5 years ago, 10 years ago.
You heard about it? Okay.
I mean, I've seen these.
You've seen them? I hadn't seen them before I watched.
I don't think I can pull it off. I don't think I have the personality for it. You got to be a real hardcore extrovert.
Yeah, you do. Yeah, you can't just walk around and not have a conversation about it.
Yeah, I don't think I'm attention seeking enough.
Right. Yeah, these are definitely out there.
And that's on me. That's my fault.
A curly pearl. Look at that. Goodness. Yeah. Well, if anything, it's kind of like a gag gift, fun gift category. But it was interesting. I was having a discussion on my critique. One part of the pitch, they had asked, well, hey, what makes you unique? Do you have any competitors? And he said, well, yeah, we do. We were the first ones on the market, but about 12 months later, competitor popped up. And he stated that, this is not something you can get a utility patent on. I had to, of course, object to that. It is, and utility, which is the the bar, right? One of the three
Sure.
criteria. Entertainment qualifies, and so I want to break. So I went through some of those criteria. Entertainment, and of course, this is.
We don't have to be saving the world to file a patent. We can be.
Yeah, exactly. The utility is so low, and you have to be able to provide some benefit.
Humor is the best medicine.
It really. Hey, I love that. Hey, we're talking about health and everything.
Yeah.
Yeah, man. Laughing heals the soul. So, ended up getting into a sort of on the fly discussion about a court case that I found about this company. So after they pitched to the Sharks, they got in some trouble. No, they didn't actually file patents, but the other company, their competitor, Beardo, you may have heard of, a competitor, probably their, Coke, their Pepsi to their Coke. They've got all kinds of stuff. They were the one to file a design patent. And I pulled that up and actually found out that there was a lawsuit from the company, the holding company of Beardo, against Beard Head, alleging design patent infringement. And it was our job over this week to go, pull up that case and kind of go through it. I'm not sure if you had a chance to. I know I was pretty busy this week. Did you go through that at all or look at it?
I'm looking at it right now. So
take a peek, and I'll pull it up too.
No,
but basically, it's you're like, oh yeah, my homework. What I thought was interesting was the counterclaim. Okay.
Yes.
So Beardo sues. Hey, we got a design patent on this beard design. Okay. Basically, it's a very simple. I pulled it up last week, where they pulled it over, and the design patent is exactly that. It's one design. That is the major limitation of a design patent, is it's one exact three-dimensional shape. It doesn't cover, the barbarians, okay, all the different variations. It's just a very limited format. So they're swinging away, trying to get some rise out of Beard Head, but Beard Head says, nope. Not only are we not infringing, you are
counterclaim
liable for. I think they go after trade dress and trademark infringement, don't they?
Yep.
And so that's very interesting. I know you're just looking at this on the fly, but what's involved in that counterclaim? What's sort of the heart of that swing back?
Yeah, so it looks to me like, looking at the synopsis of the case, and it looks like this case was remanded back down to the district court for further analysis and specific findings.
I had actually reached out to the owner. I tried to get them on the show today. They didn't want to come on. Total story. End of story is it got dropped. The case got dropped and dismissed, and they didn't want to stir up. I didn't want Beardo thinking they could come at them again, or didn't want to ruffle feathers, and the owner wasn't want to come on or have any official statement.
Sure.
So I actually got it wrong. I had assumed that there was some sort of a settlement or license that Beard Head had to pay.
But I suppose he doesn't want to kick any hornet's nest at this point.
Yep. It sort of went away. It was a mess when it happened, but he's past it. So so is that common to get a counterclaim like that? I mean, I know we're not in litigation.
We're not litigators, but I mean, I think in my experience, whenever you can bring a counterclaim, you should, right? Because at the end of the day, it's leverage towards maybe a settlement.
Okay.
And also, if you don't use it, you lose it, right? You have to bring the counterclaim.
Got it.
Now is the time. Don't want to have to bring it later. So if you're going to bring,
I see. Yeah, you'll be barred from bringing it later.
Yep. And so this, from a procedural perspective, this looks like a 12B6 summary judgment motion, right? So here, the defendant for the counterclaim is trying to get this counterclaim kicked out of court. Yeah. And essentially, the judge in this case comes back and denies the summary judgment and sends it back down to the lower court for more findings of fact and law, it looks like.
Got it.
But yeah, I mean, at the end of the day, they came back and they counterclaimed for trade dress, which is, kind of the ugly cousin of trademark law. It is. I mean, like, it's one of these things that we don't want to talk about. We don't want to do it. It's trade dress is typically reserved for larger clients with really distinctive product design and packaging. You also see trade dress in things like, I would say, interior design, right? If you have like a national chain of restaurants, you might get trade dress protection on the look and feel. I don't know if this is the case, but you go into a Chipotle and you're in Chipotle, right? It's got corrugated metal everywhere, right? Concrete everywhere. And so that, could potentially be registered under trade dress, or at least you can make the claim in common law that you have trade dress rights in that particular look and feel for that environment.
So I'm going to share. So this is Beard Head's website. This is an online retailer, right? Yep. And then we've got Beardo here.
So yeah, I mean, they're basically creating the same product, with different variations on that same product. But I would say that first one that you showed us, Beard Head, I mean, they do have their logo prominently displayed on the hats, right? So
yeah.
I don't know if that goes into the trade dress infringement analysis or not, but I would say that, you're less likely to have a trade dress issue if you're prominently displaying your logo on your product like they are.
Okay. Say that one more time so it's crystal clear.
So let me kind of paint you guys a picture here. So we're looking at an image of a man wearing one of these beard head hat face combo coverings. And they have their logo, Beard Head, prominently displayed on the front of the hat, right? Yep, so at the end of the day, like when you look at their product, you might say, hey, this looks like Beardo. But then, of course, you see that it says Beard Head, right? And so I don't know if that goes into the infringement analysis or vice versa.
Yeah.
But at least for this particular plaintiff or claimant, they have the brand listed or prominently displayed. So I would think that would go against any finding of likelihood of confusion based on the trade dress. Trade dress it's really hard to prove, too. I mean, I've prosecuted a few of these. It can't be functional, right? And so I don't know if they could even claim that this is trade dress because at the end of the day, right, it's a face covering. It serves a purpose. So I guess maybe the design elements of the trade dress, like the locks coming out that don't provide any warmth, could potentially be, categorized as trade dress. But, I'd be curious to talk to that attorney who filed these and basically made that argument because it's notoriously an uphill battle.
Yeah, I'm actually on Beardo's website. I don't even see a competitor product. They've maybe switched completely to fragrances and
beard products themselves.
Yeah, hair products. So, I mean, that is curious too. So
yeah, I mean, maybe that was the settlement at the end of the day. Like, I'll go my way, you go your way. We're not going to do the hats anymore. You're not going to do men's, facial products.
Yeah,
or health and beauty products.
Yeah, and that very well could have been a confidential settlement.
Yeah,
owner wasn't willing to share that. Wish we could have had him on. So
that's interesting. What's also interesting is that there's a claim here of common law infringement.
Okay.
Competition. So when you bring a lawsuit in federal district court, you can also bring your state level trademark claims, and you should. There's good reason to do that because you're going to get different case law potentially. You might get a different standard for damages. I mean, who knows what could be in there? But at the outset too, you also get to claim common law infringement, which doesn't necessarily need to be registered. And you can kind of make that argument that you have rights in the mark in your state, even though they're unregistered. So, yeah.
So there you go. So just to kind of bring that home for some of those who may not know, you can have rights. There are trademark rights, common law rights that basically you have just by using the mark without registration at all.
It's like a copyright. You have rights just by using selling the service or the product or offering it for sale, like you do when you create a copyright, just by creating the work, right? Now, you need to register your trademark with the federal government, with the USPTO, just like you need to register your copyright with the U.S. Copyright Office if you want to enforce that trademark and eventually, drag someone into federal district court. You need the government stamp of approval before you can do that. Common law is a way to get around that. That kind of gets into clients always ask, can I use the TM symbol or should I use the registered trademark symbol, the circle R? Yep. And of course, if you have unregistered rights, use the TM symbol. If you have pending trademark rights, use the TM symbol. If you have registered rights that are still active, go ahead and use the registered trademark symbol, circle R.